Yeah. Shame on you. Where is it? You? Shame on you. You're testing positive for methamphetamine and amphetamines. That pretty much explains everything. Shame on you. You're on this court. What's his bond?
Hang on. 15,000.
Your bond is revoked. It is $50,000. Plus, you must have a GPS device so I know where you are when you're getting your drugs.
Yeah.
And also, you need a drug patch so I know if you're using any drugs illegally at any time. Shame on you. This is a serious crime, and you're caught. This is a felony offense. We just caught you at another felony. Shame on you. You're taken into custody. That's the orders of the court. Delete. Wayne McLean.
Ready, Your Honor.
Please.
The plea, make sure he's sworn.
Where it says right him.
Big breaking.
More times you can just have a seat,
Sir, thank you.
anyway, I'll try. Okay. Everything is needs
Twenty-six CR 598 is called the State of Texas versus Billy Wayne McLean. This is in 26 CR 598, a first degree felony and burglary of a habitation.
Tommy made the offer and Jimmy accepted.
And then in 26 CR 599, illegal possession of what? Controlled substance. All right. Look at this. This is in the file here. Get you some. Appears to be a handwritten document, but the defendant writes, asking for a mental evaluation. Those things. Do you know that? Anything about
I don't know anything about it, but I've listened with him multiple occasions. I don't see any cause for the mental examination.
What do you say?
He knows what he's doing.
Is that right?
You know what you're doing. So
So you're withdrawing this request for a mental examination, are you? You have to speak out so she can. What are we going to do, Don?
please, Your Honor.
Where are we on this? He's good?
No, that's what she.
Let me see. Yeah. Shame on you. Where is it? You? Shame on you. You're testing positive for methamphetamine and amphetamines. That pretty much explains everything. Shame on you. You're on this court. What's his bond?
Hang on. 15,000.
Your bond is revoked. It is $50,000. Plus, you must have a GPS device so I know where you are when you're getting your drugs.
Yeah.
And also, you need a drug patch so I know if you're using any drugs illegally at any time. Shame on you. This is a serious crime, and you're caught. This is a felony offense. We just caught you at another felony. Shame on you. You're taken into custody. That's the orders of the court.
Before the actual plea even starts, there's a separate issue here. The defendant tested positive for methamphetamine and amphetamines while out on bond in the middle of an already pending case. That's why the judge revokes the existing bond, raises it, and adds GPS monitoring and a drug patch. It's a good example of how a new violation while a case is pending can immediately change someone's custody status, independent of how the underlying case eventually resolves.
One gets out, goes from one mess to another, one mess to another, just more serious. Shame on you. Which one is he pleading to?
Both cases, Your Honor.
All right, you are Billy Wayne McLean. You're going to start, and you understand what you're charged with in each of these cases?
Yes, sir.
Does the defendant waive formal readings of indictments and arraignments here? Can we proceed in summary?
Yes.
In summary, 26 CR 598 alleges, and are we going on just paragraph one?
That's right.
Paragraph one, it states that on or about October 10th, 2025 in Jefferson County, Texas, you committed the first degree felony of burglary of a habitation. And that is entered a habitation without the effective consent of the owner with the intent to commit the felony of sexual assault of a child. Do you understand what you're charged with here?
Yes, sir.
Do you understand what you were charged with here, sir?
Yes, sir. Yes. You both does it?
This is a first degree felony, which means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand
Yes, sir.
the punishment range applicable for this offense? An agreement's been reached where you would be pleading guilty and sentenced to 40 years in prison. Is that right?
Yes, sir.
To run concurrently with the other case, 26 CR 599. Let's see. The state jail felony of illegal possession of controlled
Yeah, but it's enhanced to secondary punishment because of priors.
This first case is a first-degree felony, which under Texas law carries a punishment range up to life or up to 99 years. The agreement reached here is 40 years within that range, but well below the maximum. Plea agreements like this are typically negotiated between prosecution and defense based on the specific facts, the defendant's record, and what each side is prepared to prove or contest at trial.
You got a prior aggravated sexual assault of a child in 2001 conviction from the 252nd District Court of Jefferson County. After that was final, you committed the third degree felony of harassment and were convicted of that in the 320th District Court of Potter County, Texas in 2010. Okay. So back to this 40-year sentence. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily?
Yes.
That is on your own free will and because you are guilty.
Yes, sir.
Going to hold that one in abeyance and for a moment and go to 599 and the defendant waives a formal reading of this indictment and we can proceed in summary.
Yes.
In summary, paragraph 1 of this indictment alleges that on or about March 17th, 2025 in Jefferson County, Texas, you committed a state jail felony of illegal possession of methamphetamine. You know, understand what you're charged with here? Paragraph 2 goes on to allege that we were convicted on February 12, 2001 of aggravated sexual assault on a child in the 252nd District Court of Jefferson County, Texas. Is that true and correct? As it is alleged in that cause number 77436, and are you pleading true and correct to that voluntarily and as it is true? And paragraph 3 goes on to allege that after that aggravated sexual assault on a child conviction occurred, and became final. You committed the offense of harassment, a third-degree felony, and you were convicted of that felony on February 22nd, 2010, in clause number 55528-D as in dogs, in the 320th District Court of Potter County, Texas. Is that true and correct as it is alleged? And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
Do you understand that voluntarily and knowingly made pleas of truth to paragraphs 2 and 3 of this indictment is enough to enhance this state jail felony to a state jail felony, though it will be punished as a second degree felony because of the prior convictions? Do you understand?
The second case here is a separate charge, illegal possession of a controlled substance, which on its own would be a lower level state jail felony. But because of 2 prior felony convictions on his record, the law allows that charge to be punished at a higher level, in this case up to second degree range. That's the same kind of habitual offender enhancement we've seen affect sentencing ranges in other cases in this series.
Yes. That means you are facing, in this case, no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And in this case, the agreement's been reached where you would be pleading guilty, sentenced to 20 years in prison to run concurrently with the preceding first-degree felony of burglary of a habitation at 40-year sentence. Do you understand how that will apply, and is that what you understand?
Yes.
If I follow this agreement as well, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Well, I'm going to try to raise this awkward device.
Want me to see if I can get it, Joe?
Today, I don't know what's going on.
Do what?
They're like they're lagged differently today. So I got it right.
So.
I can tell. Hold on. All right, once again, how do you plead in cause numbers 26598, the first degree felony of burglary of a habitation, and 26 CR 599, the illegal possession of a controlled substance, guilty or not guilty in each case? Are you pleading guilty voluntarily and
Yes, sir.
because you are guilty, sir?
Yes, sir.
And in 26 CR 599, the state jail felony of illegal possession of a controlled substance, are you pleading true to allegations 2 and 3, those prior convictions of aggravated sexual assault and harassment as alleged in that indictment? Are you pleading true and correct to that voluntarily in each case and because those allegations are true?
Yes, sir.
And do you understand by doing so, if the court finds you guilty, which I'm going to do in this particular case, that this constitutes a state jail felony, although it is punished under law as though it were a second degree felony?
Yes, sir.
I show you in each case what's marked as State's Exhibit 1. Did you sign those documents, understand them, discuss them with your attorney?
Yes,
Or the contents are true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in
No
each
objection.
case without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments that have been read to you, you've read them. You were guilty of each of these crimes in 26 CR 598 and 599. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. pre-sentence reports are waived in each case?
Yes, sir.
I'm going to follow these agreements and find in each of these cases you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Is there sufficient evidence supporting your guilty plea in each case because of State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt in each case? In 26 CR 598, the first degree felony of burglary of a habitation, you are hereby found guilty of that offense as alleged in the indictment. I am following that agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. And that's, and the indictment and the records will reflect that burglary involved the intent to commit a felony offense of sexual assault of a child. And in 26 CR 599, I hereby find you guilty of this state jail felony, but also paragraphs 2 and 3 have been proven true beyond a reasonable doubt, which constitute a state jail felony, punished as though it were a second degree felony. And I find paragraphs 1, 2, and 3 true and correct. And you were found guilty of those 3 allegations, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years in that case. These sentences shall run concurrently. Do you understand what has happened in each of these cases, sir?
Yes, sir.
Anything else? That is all. That's all.
Both sentences, 40 years and 20 years, run concurrently. So 40 years is the effective total here, the longest sentence we've covered in this series so far. These are heavy cases to sit through, but they're a real unfiltered look at how the system actually processes them from bond to plea to final sentence. If you want to keep following how these hearings play out, hit subscribe and let us know in the comments what stood out to you in this one.